This case is just like many of the shooting deaths we've had in our circuit. If stand your ground becomes an issue, we fight it if we believe it's the right thing to do. So if it becomes an issue in this case, we will fight that affirmative defense.
That was Special Prosecutor Angela Curry last night vowing to fight the controversial Stand Your Ground law. It's the law that says you can use deadly force if you feel threatened to prevent death or great bodily harm. And it's game on because George Zimmerman's lawyer indicated last night that Stand Your Ground would likely be part of their defense.
Right now, it's the law of Florida, and it's the law that's going to have impact on this case.
Since the law went into effect in Florida 7 years ago, it's been very controversial. The Tampa Bay Times compiled the numbers. There's been 130 cases. In 10 of those cases, the defendant pled guilty to lesser crimes. 28 cases went to trial, and 19 cases got a conviction. That's a 14.6% guilty rate for people who used Stand Your Ground as a defense. It's not very high at all. But in the case of George Zimmerman, will his claim of self-defense under that Stand Your Ground law hold up in the court of law? Joining me now, Ben Montgomery, staff writer for the Tampa Bay Times, who reported those Stand Your Ground numbers we just showed you. And back with us, Ken Padowitz, a former homicide prosecutor who's also defended clients under Stand Your Ground in Florida, and John Burris, an experienced criminal defense attorney. Ken, can you help us understand the Stand Your Ground law, and will it stand in this case?
Absolutely. Basically, you're always entitled to an affirmative defense at trial called self-defense. What the Stand Your Ground law is the legislature came in 2006 in Florida, and they basically created a statute which is an immunity statute. It gives immunity where the charges have to be completely dismissed by a judge if there is a hearing, a motion filed by the defense asking that the statute be applied, and there's a hearing, literally a mini trial that is conducted in front of a judge. No jury is present, but it's conducted in front of a judge, and the defense has to go forward and present evidence, present testimony, and there's cross-examination, direct examination, and then the prosecution presents their evidence. So literally there's a full-blown hearing, a mini trial that takes place if the defense elects to ask the judge for immunity. And if immunity is granted, that means the charges are dismissed.
Now, John, given what you know and about the evidence, because, again, we don't know what we don't know, of course, is it likely that a judge would feel that he could throw this out?
No, I don't think it's likely that he could throw it out because of the initial confrontation or the initial following of Trayvon by Mr. Zimmerman. He was the aggressor. He's the one that started. He left a position of safety, not only in his car, but he was traveling. So once you leave the position of safety, I think you do not get that level of immunity after that. Now, you could have another self-defense argument at trial, but certainly the most important thing one should keep in mind here, though, on this Stand Your Law, when you have this mini trial, the standard of burden of proof is a presumption, a preponderance of evidence, which is a much lower standard. So you don't get proof beyond a reasonable doubt. The prosecution doesn't get that now. What they get is preponderance of evidence, which is more likely true than not. So the prosecution has some work to do here, but I think the initial portion of it is that this particular person was the aggressor, and it has to be reasonable. It's not just complete immunity. It has to be not only a fear, but it has to be reasonable. And so I think the judge can have really make that decision on the grounds that it was not reasonable for the person to leave. It was not reasonable for him to place himself in a position of confrontation, and he was the aggressor. So therefore, he doesn't get this particular defense before the trial starts. So I don't anticipate this being thrown out.
Ben, you've studied these cases and you've come up with the numbers. Have you in your studies come across any cases that are similar to this? Or if not, then what are the kinds of cases that usually uses Stand Your Ground so far in Florida?
Yes, sir, we have. In fact, I've found about a dozen cases that have similarities to the Trayvon Martin case, and I beg to differ with the gentleman who was speaking earlier. In those cases where someone initiates a pursuit, initiates a confrontation, it's not rare for that person to be granted immunity in Florida courts. What matters is not what happened 5 minutes before the event. What matters is what happens in the 60 seconds or so prior to the use of deadly force. So it doesn't matter if someone chases someone so long as they have a legal right to be where they are, so long as they're not in the commission of a felony. If that person who initiated the pursuit, initiated the confrontation, then has to use deadly force to defend him or herself, if he can convince a judge that he reasonably believed he was in danger of great bodily harm or death, he can and sometimes does get granted immunity.
Ken, but how do you do that in this case if this young man only had Skittles and iced tea and was not involved in a crime and had a legal right to be there?
Well, that's what makes this so problematic. I think it's very, very unlikely for a judge in this case, from the evidence that we're all talking about, to grant immunity to Mr. Zimmerman. When Mr. Zimmerman is the aggressor, there's a Florida statute directly on point here that says if you are the aggressor and you initiate, by being the aggressor, the contact, you can't then turn around and say immunity applies and I should receive immunity. Now, the fact that it's been done before by courts, that doesn't necessarily mean that the law was followed properly or that it's going to be applied by a judge in this particular case. I would suggest that based on the evidence that that what we're talking about right now, that it is a very unlikely scenario for someone who's being the aggressor, who's armed, who provokes the confrontation to turn around and claim that the stand your ground law applies. In fact, I would suggest that Trayvon Martin would be able to use this had he been alive, that he could claim that he, in fact, was being attacked, and he has the right to defend himself under the stand your ground provisions.
John, I see you nodding your head.
No, I agree with that. I've always thought that the stand your ground thing was being misplaced for Mr. Zimmerman. This really, Trayvon is the one that was actually being attacked and confronted. He had a right to defend himself. And so to the extent the other guy had the gun, unfortunately, that person is the one that I don't think, who was the aggressor, can in fact claim it. At the end of the day, Trayvon should have been able to claim it. Unfortunately, he's not going to be able to testify. You'd have to, but that only goes to the issue of whether or not the judge would allow Mr. Zimmerman to claim it. And I agree that I don't think that's going to happen because at the end of the day, it's a reasonable standard as well. And though judges do things differently in different courts, obviously it's up to this particular judge, but I think he will have the facts to say, I don't think an immunity should be here at this point.
Ben, maybe that's the reason why in the affidavit for probable cause the prosecutor released today, they took pains to establish that in fact, Trayvon was there legally, was going home to where he was living, and was not committing a crime. It looked like they went to pains to clearly establish there was no reason that he was not there. So it will start with the frame of mind. You say that it goes to the 60 seconds before the fatal, in this case, shot. But with no witness there, he'd have to convince a judge that what he saw was believable. He doesn't have an eyewitness, and the 911 tape certainly doesn't help him.
And that seems like it's a problem on occasion when this law is invoked. It asks the police first, the prosecutors second, and then a judge, and occasionally, when these cases do go to jury, a jury, it asks them to consider something as nebulous as a man's mind. What was his frame of mind in the moment he used deadly force? And did he reasonably believe, can he establish that with the facts, did he reasonably believe that he was in fear for his own life? Let me just raise one case, the case of Grayston Garcia, which was a gentleman who was granted immunity in Miami-Dade about 2 weeks ago. He was upstairs asleep in his apartment. His roommate alerts him that somebody was burglaring was stealing his stereo out of his truck. He gets up, grabs a kitchen knife, runs downstairs, doesn't call the police or anything like that, runs downstairs. The thief grabs the radios, grabs a bag of radios, and takes off running down the street. Garcia pursues him. About a block away, catches up to him. The thief turns, swings the bag of radios at Garcia's head. Garcia blocks the radios and stabs the thief in the chest. The thief dies in the street. Garcia sells the radios, doesn't tell the police that he's involved in a crime, in a murder, in a death, and he was granted immunity. These things are playing out.
Yeah, but you're dealing, I wish we had more time, because you're dealing with two people with weapons, you're dealing with a crime. I don't know that this is the same kind of case. Well, anyway, this is going to be a big part of this case, and we'll certainly be talking more about it. Ben Montgomery, Ken Padowitz, and John Burris, thank you for your time tonight, all of you. Stay ahead.
Thank you.
How the activist community brought national attention to Trayvon Martin's death, and why some on the right just don't like it.